In 1967, the Supreme Court ruled unanimously that race cannot be used as a basis to restrict marriage in the United States. This was a famous case. You learned about it in high school. Loving versus Virginia. The amazingly named Lovings were Richard and Mildred Loving, and in 1958 they left Virginia and traveled to Washington, D.C. so they could get married. When they returned to Virginia, where interracial marriage was against the law, they were sentenced to a year in prison for getting married. When the judge in Virginia sentenced them to prison, he said, quote, "Almighty God created the races, and he placed them on separate continents. The fact that he separated the races shows that he did not intend for the races to mix." The Lovings appealed that decision and eventually won at the Supreme Court, thereby changing the law in the entire country. But why did it take until 1967 for the Supreme Court to weigh in on interracial marriage? By 1954, a full 13 years earlier, the court had already ruled in cases involving race and segregation and discrimination, perhaps most famously in Brown v. Board of Education, which the court held unanimously that separate but equal was unconstitutional. So again, why wait until 1967 to hear the case about interracial marriage? Here are all of the states that had laws on the books in 1947, banning interracial marriage. Most of them, right? By 1967, only 16 states still had those laws on the books. In the 2 decades between 1947 and 1967, the years the Supreme Court was staying mum on the issue, most states decided on their own that it was unconstitutional to ban interracial marriage, or at least unwise. The court was following the heels of public opinion. This is a big debate in the legal world. Is the Supreme Court influenced by American public opinion? These are 9 people who very well could completely ignore the will of the people. They are appointed for life, no elections, no accountability. They can totally ignore us if they so choose. But many legal experts say that is not how it works. Supreme Court justices are, in fact, swayed by what people in this country think about issues. Today, the Supreme Court announced it would hear 2 cases involving same-sex marriage next year. That is huge. They said they would hear the Prop 8 case out of California. Prop 8 is the California ballot proposition, which amended the California Constitution to define marriage between a man and a woman. The court will rule sometime this year, probably in June, whether that amendment is unconstitutional. But the court also said it would hear a challenge to the Defense of Marriage Act, a 1996 law passed under President Clinton that defined marriages only between a man and a woman for the purposes of federal law. So the question is, why now? Why did the Supreme Court choose this moment? Well, 9 states and Washington, D.C. all recognize same-sex marriage now. That doesn't seem like very many, but it's happening quickly. 3 of those states, Maryland, Maine, and Washington, in those, people voted to legalize marriage just in November. First-time voters have ever done so. And there's a big public opinion trend here. Since 2004, the Washington Post ABC News poll has been asking people, should it be legal or illegal for gay and lesbian couples to get married? In 2004, 59% of people said they thought same-sex marriage should be against the law. In 2012, it was almost the opposite. 53% favor making it legal. Pew has been asking the question since 1996, when 65% of people were against same-sex marriage. By October of this year, 49% were for marriage equality, while 40% opposed it. One more set of numbers, even more telling. Gallup released its most recent polling on same-sex marriage this week. 53% of people polled support legalizing same-sex marriage, which ties a previous record high. But look inside the poll. Among young people, 18 to 29-year-olds, 73% say they think same-sex marriage should be recognized as valid. 73%. So here's the question. The court is choosing to rule now. Are the justices looking at these trends and saying we need to use our power, our insulation from public opinion to put a stop to this? Or are they looking at these trends and seeing a chance to join history, to become the court that said gay marriage is protected under the Constitution? Joining us now is Kenji Yoshino. He is the Chief Justice Earl Warren Professor of Constitutional Law at NYU Law School. Kenji, thank you for being here tonight. That is a great title.
Thanks, Ezra.
So my question for you is simple. It's 2 words. Why now?
Well, in part it's because the court is a very passive institution. It can't reach out and grab cases, right? But I think that there's an additional layer to your question, which is why didn't the court just say we're not going to review this case even if it's being petitioned to us? One of the cases that we didn't look at in your excellent introduction is a 1956 case called Name versus Name. This is right after Brown versus Board of Education, when the court is handing out these per curiam orders extending the desegregation principle to public accommodations. But it has a marriage case come up before it, and then on completely unpersuasive grounds gets rid of it and says, this is too soon. And so it waits, as you said, until 1967, a full 11 years later, to take it up. So many of us thought, this is exactly what's going to happen with the Prop 8 case. I think the DOMA case is slightly different for reasons that we can go into. But I think many of us thought the Prop 8 case are just going to deny cert. It's going to go back. Same-sex marriage is going to be legal in California, but nowhere else. And then the court is going to wait another 10 years and then wash out the outliers as it did in the interracial marriage context.
So what are the differing implications of how they could rule in the two cases? What different parts of the gay marriage question could they resolve?
Right. So the DOMA case is a much more easy case from my perspective. It's a much more parsimonious challenge in the sense that all it does is to return Congress to its original position of following whatever states' definitions of marriage are. So in some ways, the suit was very ingeniously crafted because it's a kind of pincers movement. The conservatives in the court tend to be very pro-states' rights.
Right, it's a states' rights solution.
Exactly. And then the liberals tend to be very pro-gay. So essentially, when you're arguing towards the middle with Justice Kennedy, these are like Justice Kennedy's most favorite things, right? States' rights on the one hand, gay rights on the other. That's clearly a fifth vote, right, for this case, right? We assume, right? So I think everyone imagined, especially since a federal appellate court had struck down a congressional statute, that almost invariably leads the Supreme Court to review the case. So almost everyone thought that they would take the DOMA case. I think they're going to do the right thing in the DOMA case and strike it down.
Okay, so
the Perry case is much more complicated because the DOMA case doesn't affect any state's decision as to whether or not to allow same-sex marriage. Whereas the Perry case, the outcome could be...
And again, Perry case is the Prop 8 case in California.
Exactly, yeah. Thank you for helping me out there. So the Perry case says, there's this definition that was passed by a ballot initiative in 2008 that says that marriage is between one man and one woman. Right? If the Supreme Court goes really broad on that and says that there's, for example, a fundamental right for same-sex couples to marry, that could flip the remaining 41 states that don't have same-sex marriage to require them to have same-sex marriage. I don't think that's going to happen, Ezra. I think that there are many way stations in between 0 and 50, right, with respect to solutions. So, for example, the court could look at this and say there are a bunch of states, there are 8 states that say we're going to give you all the rights and benefits of marriage, but we're going to withhold the word marriage, and that's all we're going to withhold. The court could look at that and say, all you're worried about is brand, and what you're saying is that if you let gays into marriage, that's going to diminish the brand. That's animus. We're going to strike that down. We're going to add those 8 states to the ledger of the 9 states that already allow same-sex marriage, bring the total to 17. And then somewhere down the line, we'll do the Loving versus Virginia move of washing out the outliers, which, as you said, in 1967 was 16 states. Right now, it would be washing out 41 states, which is a much bigger proposition.
So very quickly then, before we go, today is a good day for supporters of gay marriage. That's the bottom line, or in your?
I think it's a great day, and I think it's a great day because in the Perry case, there's no question it's a great day with respect to DOMA because I think people are confident that will come out in the right way if you're on the pro same-sex marriage side. For the Perry case, I think it's a great day, even though there might be skeptics on that issue, because in that case there is a beautiful record. There was a trial in this case, and whenever there's a trial, the pro-gay side wins. That's almost a per se rule. So in very red states like Arkansas and relatively red states like Florida, the gay rights activists have won. In very blue states, without a trial, we've lost in states like New York or Maryland. So because there was a trial and a 3,000-page record that the Supreme Court will look at, I think the Perry case is actually a sleeper winner.
Interesting. NYU's Kenji Yoshino, thank you so much for being here tonight.
Thanks so much for having me.
If you are former President Bill Clinton, you have a global initiative named after you. If you are Edwin Hubble, there is an awesome telescope named after you. If you are George Foreman, 5 sons named after you and grills. I am Ezra Klein, and the only thing named after me is the challenge we sort of invented here when I explain really wonky stuff quickly. And I'm okay with that. Tonight's Ezra Klein challenge is next.